Hi again, everybody. Thank you guys for joining us, and thanks to the people who joined early. Uh, as I said before, I'm Nadine Atkinson Flowers. I practice immigration law in the US, and I also practice in Jamaica. I'm joined by my colleague, Courtney Foster. She practices in Jamaica. We thank you for keeping your audios muted, but if you want to ask a question, please feel free to go ahead and unmute and ask. Ideally, we'd love if you ask the questions at the end, but we understand that sometimes the question might be burning and you think you want to ask it before, or certainly if you wish, you can drop it in the chat. Also, just to indicate to persons that if they want to turn their cameras on, they can do so. If they don't want to, that's perfectly fine. We're live streaming on a number of channels, and I know sometimes persons may figure for their privacy and so on. They may not want to put their cameras on. Totally up to you, judgment-free space. We're here to share the information that we have and hopefully to hear concerns, issues that persons might have. One very important caveat that we have is that this is not legal advice. Every case is different, and we're here really just as attorneys to share the information that we have as it relates to what's happening now in the immigration space, some of what's happening in Jamaica in terms of some of our various legislation and cases. So without further ado, I will give my friend Courtney the floor, and then, we'll kind of tag team as we go along.
Thanks, Nadine. Good morning, everyone. Thank you for tuning in. All right, so I'll be speaking on criminal law matters. Criminal law is one of my main areas of practice. And just to give a little background, I've been practicing for 15 years. I have appeared before all the courts in Jamaica, and I've also appeared before the Privy Council, albeit my Privy Council appearance was not a criminal matter, but I've appeared in the Court of Appeal, the Supreme Court, the Parish Court, the Petty Sessions Court. All right, so some of the general areas that I'd like to discuss are terms that perhaps you might not understand. You might hear it in the media and you wonder what they are. So let us just begin. All right. So when we're looking at bail, bail is always a big area that persons want to discuss in criminal law. And they always say, well, I don't understand bail, what is expected of me, etc. Now, if a person is taken into custody, once the person has been detained, sometimes when we think about custody, we think about a jail cell. But what you have to consider is whether or not your freedom of movement has been restricted. So if you have been taken to the police station and the officer tell you to sit down on the bench and you can't go anywhere, the period of detention starts at that time. So you need to consider that, because if a certain amount of time has elapsed and there has been no charge, an application can be made to the court. And the name of this application is a habeas corpus application. So that kind of application, usually it is done by an attorney. What we do, we go to court and we present the circumstances to the judge. So we'll indicate that John Brown, for example, has been at X police station for the past 4 days. He has not been charged, and we are presenting that there is no lawful basis on which he should remain in custody. The judge in that circumstance can do an investigation, meaning inquire from the police, why is John Brown there? So sometimes the person who is being detained, the police may have an interest in doing an identification parade. So let's think about it practically. If John Brown comes out of custody and then he's placed on an identification parade, there might be a risk of exposure, meaning that somebody might see him. So the police might say, we want to keep him because we need to conduct an identification parade. If, however, sufficient time has been afforded to the police, it's within the judge's power to consider that, yes, albeit that you want to do an identification parade, John Brown has been in custody for 7 days and you have had more than enough time to put your affairs in order. And then the judge can make an order for the immediate release of John Brown. So that's just one example of how a habeas corpus application can operate. Now, let's say John Brown is in custody. The police can, as I said, conduct an identification parade. They can also ask him questions, and that is called a question and answer interview. And that question and answer interview is usually conducted in the presence of an attorney, and if an attorney at law is unavailable, it can be conducted in the presence of justice of the peace. Now, for the question and answer interview, there are certain rights that the suspect has. Now, ordinarily, question and answer interviews are conducted before a person is charged or released. But there is provision in the law where a question and answer interview can be conducted post-charge, but that is done in very rare cases. So the question and answer interview and the identification parade are two things that can be conducted. So let's say with St. John Brown, those two things are done, and then he is charged. He needs to be placed before the court within a reasonable time so that the judge can consider the circumstances, because bail is a matter, one would say, as of right, unless there are satisfactory grounds that can be shown as to why the person should remain in custody. So what are some of the things that the court will consider? They'll consider whether or not the person is a repeat offender, whether or not the person is likely to commit an offense while on bail, whether the person is likely to interfere with prosecution witnesses, whether or not the person is likely to attend upon the court when required to do so, whether the person going to jump on a boat and disappear. Those are some of the factors that the court will consider. Okay? Now, that is just a little discussion as to some of the things that can happen when somebody is going before the court. Now, for the trial process, a trial will take place where a person, the defendant, enters a plea of not guilty. So if the person enters a plea of guilty, there's no need for a trial. That the matter will then move to sentencing. But if the person enters a plea of not guilty, the burden of proof is on the prosecution. General burden of proof is on the prosecution, and they must prove that burden beyond a reasonable doubt. So, as a defendant, will have the right to question those persons who are coming to make allegations against you. And that is what we call cross-examination. And the trial process can be conducted in the parish court and the Supreme Court based on the types of offenses. But you have some offenses that come under what is called the Committal Proceedings Act. So those matters are not tried in the parish court. A hearing is conducted, and what the Committal Proceedings Act allows is that it's mainly paper proceedings. So the statements, any exhibits, etc., are in what is called a committal bundle. The judge will then examine that and determine whether or not there is a sufficient case to send to the circuit court or the Supreme Court. Okay, so that is a different procedure. But in terms of trial matters, summary and indictment matters can take place in the parish court. And as I said, there are trials that take place in the Supreme Court. So if a person is convicted, what option does that person have? The person has the option to appeal the decision. So even if you have a jury trial, a defendant who has been convicted has the right of appeal. But one has to note that there is a timeline for filing an appeal, and of course it will depend on the type of matter. So whether or not the trial was conducted in the parish court versus in the Supreme Court. And you appeal your matters to the Court of Appeal. If you're dissatisfied with the decision of the Court of Appeal, it's open to you to go to the Privy Council. That is the court that is in the United Kingdom. All right, so that is what we call our final appellate court. So that is generally the process as it relates to criminal matters. And I will say, if the person enters a plea of guilty, as I said, there will be no trial, but what the next step will be sentencing. And at a sentencing hearing, you can call character witnesses on behalf of the defendant. the judge can take that into consideration in order to determine the applicable sentence. Now, where a person has a conviction for certain offenses after the prescribed period, you can apply for the expungement of your record, meaning you get a clean slate, a new lease on life. But it's not for all offenses. It depends on the type of offense, whether or not it's a custodial offense. And if it's a custodial offense, the length of time that was that for which you were sentenced. So that is where you have an expungement, and you can do that process right here in Jamaica. All right, so the other point I'd like to quickly discuss is an application to relist. I get a number of those matters. So suppose you had a matter before the court, and you said, boy, Miss Foster, so that matter was before the court like 10 years ago, and I don't know what happened to it. I can't remember. And me not think me got to trial, I want to find out what happened. It is open to you as the defendant in that matter to apply for the matter to be relisted before the court. So that simply means that the matter gets put back before the court. And that is a process where we will try to locate the file, look at what was the last notation in terms of the matter, and see how best we can have the matter finalized. So that is an application. I've had quite a number of matters, and you cannot, and one of the things I like to caution persons is that do not leave your matters hanging. If you believe that you had a matter but there was no finality to it before the court, approach an attorney and discuss whether or not you can make an application to relist. Because oftentimes what happens is that when persons go to get their police record and they're calling Mrs. Atkinson Flowers to now do them immigration process, and them see that there is this matter pending on their record, and all of a sudden they realize, oh gosh, say I never deal with this 10 years ago. So it is very important that you treat with those. And lastly, as my general point, when we're considering children are treated specially under the law. So sometimes you'll hear about the children's court. That is a court that exists not in every parish. So if a parish doesn't have a children's court, the matter is put before the family court. So for example, in Kingston and St. Andrew, we have the Kingston and St. Andrew Family Court, and children are brought before the court, and the same kind of considerations are had as it relates to the question of bail. But of course, there is legislation, particular legislation as it relates to child defendants that the court will take into that the court takes into consideration. And so there's a different process as it relates to child defendants. So in a sense, that is what it is in terms of the criminal process and certain steps that are available to you. And I'll make this point. Once you drive a car in Jamaica, you have to take note of what is provided under the Road Traffic Act. And why do I say that? If you have the unfortunate experience of driving your car and you hit down someone, you can be placed before the court. And if the person dies, you can be placed before the court for causing death by dangerous driving. That is something that is a very serious offense. And so sometimes we think about it and say, oh, road traffic court, no big deal. But you have to consider the other offenses that can flow from a traffic accident. So as road users, make sure that you read through your traffic act, your road traffic act. And as I said, consider where there is any pending matter that you might, criminal matter that you might have, consider approaching an attorney at law. And if any at all you have the unfortunate experience of being detained by the police, remember you have the right to an attorney. And if you cannot afford an attorney, one will be provided for you by the state. All right, so that is what I wish to discuss as the introductory topics.
Thanks, Courtney. I'm gonna jump in with a couple of the things that you mentioned, about three of them, in fact. The Road Traffic Act. Usually, and I'm sure every practitioner who is on here, yourself included, as a criminal law practitioner, when you say to somebody, I practice criminal law, they say, me not need no criminal lawyer, me not do nothing. But Courtney makes an excellent point, because you do not have to do nothing in the traditional sense of running out there with a firearm and shooting someone, for a criminal charge to fall upon you. As she says, you can be busily driving your vehicle along the streets, and unfortunately you hit someone, that person dies, it's a causing death matter. So just that's a very, very important point that Courtney makes as it relates to criminal law prosecutions in Jamaica. As it relates to the matter of sentencing, for my part, now that I practice more US immigration than Jamaican criminal law, I see persons who say that they don't have any convictions. Fine, that is wonderful. However, when they get the police record, it might say such and such happened or such and such still needs to be dealt with. And I'll be like, so you say I never have any conviction, sir? What's happening here? And they will say, oh, but I wrote sentence me get, man. Me get suspended sentence, or they may say get probation or whatever it is. No. For immigration purposes, it is absolutely vital that should such a thing happen to you, you indicate it. In Jamaica, a lot of times persons say, we get a road sentence, which means that there was no going to prison, as it were. Or you may have only spent a few days or a few weeks, few months in jail, and then you were hopefully acquitted of the heinous charges that were proffered against you. However, that is something that you still need to disclose. There are too many persons who unfortunately lose the immigration benefit that they have, or it ends up being long delayed because of this lack of understanding on their part. I do not want to say it is any more than that, because sometimes it is really that people didn't understand that they need to say this happened or that happened. And as it relates to the expungement, there are certain offenses that you can have expunged, but even if you have it expunged, you still need to disclose it for your immigration purposes. Here in the States, they have persons who they actually go and they try to get a pardon, or they approach the state government for different types of relief from whatever criminal issues they might have had, and they get it, wonderful. But for immigration purposes, those are still alive and well, if only for you to disclose it to US immigration so that you don't lose your immigration benefit. Because to be accused of fraud or misrepresentation, meaning you knew this was happening, you wanted the green card, you wanted your work permit, so you tricked us by not disclosing it. When in truth and in fact, it is not that I tricked immigration. It is more that I did not understand that having an expungement or getting a pardon, or eventually a not guilty, if it, excuse me, if it were that you were a trial getting a not guilty in a case, does not absolve you of the necessity of advising US immigration. And this sometimes catches us in Jamaica when we put in for our visitors' visas, which is what almost every Jamaican at some point in time put in for, our visitors' visa, whether we're little children or we are 75 years old, whatever. And if it is that something happened that brought you into contact with the criminal law, you need to say that, because I can assure you that USCIS and the rest of the immigration machinery, they have a very long paper memory, which probably is a good place for me to indicate that your preparation for a successful US immigration case begins long before you submit those documents. Therefore, it is incumbent upon you to ensure that every single piece of evidence that you're going to be putting towards your application, it's clear, it's precise, and it is truthful. And as such, how do you start then? If you are applying for your visitor's visa, everybody likes to say the B1, B2. if you're applying for that particular visa, make sure that you read all the questions very, very carefully. If you are making the application yourself, read it very carefully. If you're utilizing the services of a travel agent, some persons say that, and it's my fault that the agent to do it. That's not the point. It is your document. You're the one who is going to sign it. And as such, you cannot be heard to say, it's not my fault, it is your fault. You should have read it carefully. You should have been adamant that so-and-so happened and they need to put it there. So you have to make sure that the application is as precise as possible. Another area that I see from time to time is that persons who are in what we Jamaicans colloquially call common law marriages. We write on our US immigration documents, whether it is a visitor's visa, student, whatever it is, that we are or we were in a common law marriage. But we know as Jamaicans what we mean when we talk about a common law marriage. I am involved with John Brown. We are not married as in there's no ring that we went to church and put on, or if we are Muslim or whatever, a religious house and put on. But rather, we have been together for 20 years. We all start look alike. We have a number of children. We have assets and so on. I hold myself out as Mrs. So-and-so because that's what everybody call me because they understand. He holds me out as, yeah, man, a wife that she there home, call her about so-and-so and so. So when I go up to the embassy, I say, yes, I am in a common law marriage. I get my visitor's visa or student visa or work permit, whatever it is, and I come to the US. When I arrive in the US, for whatever reason, the relationship with me and Mr. Gentleman in Jamaica has broken down. I have now found a new love in the United States, and he and I marry in a religious ceremony, ring is on finger. We went and we put the documents in to the courthouse or excuse me, and the state has a record that we are married in the same way that if you got married in Jamaica, you would go to the RGD and indicate to them that we are married and they give you the paper, that pretty paper, marriage register. So here it is now. I am now married, as it were, legally married. This gentleman now proceeds to put a petition in for me to USCIS. It's called the I-130, Petition for Alien Relative, so that I can get my green card to remain in the US. When we submit the documents, USCIS, which is United States Citizen and Immigration Services, sends back a very long letter to say, oh no, Miss Nadine, you need to come talk to us because you were involved in a common law marriage in Jamaica and we need proof, excuse me, that that common law marriage has actually ended. And I'm like, what am I talking about? Me never married, me and a boy never married. However, that is not the problem of the US government. They now need you to bring forth this proof that you were never married, or if there was such a common law marriage as they understand it, it has ended, because now you're dealing with two separate legal systems, two separate cultural systems. And I think a lot of us don't really realize that we're dealing with literally two ships passing in the night as it relates to what happens in the US and what happens in Jamaica for this particular process. So now you will have to provide documentation to say, whilst he and I lived together for 10 years, we never actually went through a religious ceremony so that he and I, in the legal language of the US and even the legal language of Jamaica, were married. And there is no document to show that we were married at the RGD. And in fact, in Jamaica, there is no document that says once you have signed it, you are now in a common law union or you're a common law spouse. If you wish to be considered as a common law spouse in Jamaica, there's a very specific procedure that one has to approach the court with. And usually that's in cases where the gentleman and I have lived together for so many years and we've acquired many assets, and now there's a break in the relationship and him no want give me nothing because him say, you don't deserve it, whatever. And so I must approach the seat of the court to plead my case and to say, we were in this relationship for, is it 5 years, Courtney? That it has to be 5 years minimum. He's a single man and
Yes,
I'm a single woman. Single. So you can't be separated from your married spouse and you and Johnny over that side, or Johnny over that side with Mary, and she has a spouse in the meaning of the law. So all of these things have to be done for you to convince USCIS that you actually were not married in the sense of the Marriage Act, and therefore would not have needed to approach the court for a divorce in the sense that Jamaicans understand it and in the sense that Jamaican law understands it. I've had a number of cases where I've had to do what we call an expert's report to indicate this is something that we use as a term in Jamaica, but here are the pointers that indicate that there is no actual marriage. And it does take a significant amount of time, a significant amount of effort, and a significant amount of expense to convince USCIS that you truly were able to marry when you did in the States. Because obviously, it is almost akin to them saying you have committed bigamy. You know, you've married someone else whilst you were still in a subsisting marriage. So that's a very important thing to remember as it relates to how to prepare your documentation for success, even before you submit that application. Another thing that is important, we're going to talk a little bit more about it, maybe in another 20 minutes, as it relates to what's happening now in the States, because I think maybe a lot of persons are keen to talk a little bit more about that. The whole issue of children. When USCIS asks you about children, they do not mean simply the children that live with you. They mean the children that are dead. They mean the children that you not chat to because they're worthless. They mean the children that have now lived in Australia for 15 years and they have not been in contact with you. They mean the children who have been deported, such as when we just say, your things change. All of those. They also mean the children that you had with that man who now you hate like poison. Every single child that you have had, you must indicate. If you have adopted children, you also must indicate about those. Because a lot of times persons only indicate the children that are living with them at the time. And some years later, they decide that they are going to file petitions for those children whose names did not appear on the various documentation that they submitted to USCIS. The government now says to you, but Nadine, oh, you have one 25-year-old, when you initially submitted that you only had 2 3-year-olds, or whatever the number it is. I cannot now be heard to say, you know, man, the girl never did a talk for so many years, and therefore I did not put her on the documentation. That will not fly. The first thing that the government is going to accuse you of, and this is what you do not want, is fraud. Lying. Let's just be blunt. They're going to say, you lied about it so that you can get this benefit. There is nothing to be gained by lying about the number of children that you have. In the case of a child who unfortunately died, you can sort of get away with it by saying, but it says list all children, and Johnny died when he was 14. You may be able to get away with it with enough vigorous representation on your part by an attorney, or if you can do it yourself, that's fine. But the circumstances in which you will be able to proffer a explanation that is acceptable or taken as true are very, very, very few and far between. So that's another thing to basically make sure you're setting yourself up for success before you actually submit an application to USCIS. Another thing that I think it's important for
Might I just add, sorry, before you go on, just quickly about the common law relationship. Sometimes persons don't remember that you can make an application for a declaration of common law relationship in the court in Jamaica, but it's open to the other party to challenge that application. So just like what Mrs. Atkinson Flowers was saying, that other person might say, I wasn't single, me and this person never did, it was just like a visiting relationship, it's not too serious. And that happens more often than you think. So sometimes when persons say, oh, marriage is not important, you have to understand that there are legal implications for not being married. And if you're trying to go on a common law relationship, you really have to prove that me and this person were together. And as Mrs. Atkinson Claus said, that person was single, that I was single, and that we were together for 5 years. So I just wanted to add that little one.
And it's so important now, I think, that everybody has access to so much information in Jamaica about what the law says. Yet, even though we have so much access to information, there's still a lot of misinformation. There's still a lot of instances where people say, but me never know that. Listen, information is there, and there are places that you can go to get good information. And it is important, it is critical, it is so vital to make sure that you have documentary proof of things. I always say to my immigration clients when they say, but my marriage real, or do you mean my marriage not real? I say, listen, think about it like this. You come to it from a position of my marriage is real. They come to it from a position of we don't know if this marriage is real. You have to prove it. Hence the need for documentary evidence, which is the next thing I think that I want to talk about, documentary evidence for your cases. Everybody has only pictures on their phones now of how lovey-dovey they have been for the last 20 years. USCIS does not wish to see 400 pictures of you and whatever his name is or her name is in various places having a grand time. They will be happy to look at a few photos that show the totality of the relationship. However, they're not, and I can guarantee they're not going to look at 100 pictures of you and your loved one, whether it's a spouse or a child or whomever. They require significant evidence to show for a marriage-based green card, for example, that you have commingled your lives together. And that's a word that the law uses. You have commingled your lives together. So from the outside looking in, looking through that glass pane, we, USCIS, can see that you, Mr. and Mrs. So-and-so, have put your lives together for the long haul. Therefore, you will have documentary proof of all the things that you have done to put your lives together. So the video that you did and put it up on TikTok and it went viral is very important, but only to you. It is a requirement that you submit paper to USCIS. And there's a very good reason for that, because they are supposed to make an objective decision on your case based on what you have submitted. They are not going to stop and look at 20 videos. I have to tell my clients that all the time, please do not send me all these videos because me not look on them and USCIS is not looking on them either. Worst case scenario may take a few screen grabs if it really is very impactful. But for the most part, they do not look at videos. I had a case where we went to our adjustment of status interview, which is when you get your green card here in the US as a person who came from abroad. And the couple they have a TikTok channel because one of them have a particular medical issue. And so they were talking about their journey into finding more information about this issue and getting support from the wider community. And so they have this channel, which does get a good amount of views, as it were. And the officer asked if they could see it, and they showed it to the officer. Now, those instances are few and far between, but it was very impactful because of what it was. But as I said, those are few and far between. Paper is what they want to see. And I guess that also perhaps leads to the issue of making sure you keep copies of your documents. Too few persons take an active role in their cases. If your husband is submitting the petition on your behalf here in the States, or you're in Jamaica or wherever it is you are, each time he or she sends off documents, you should say, send a copy of it to me, and let me keep it in my file as well. Send a copy of that, let me see it. And if you're working with an attorney, it applies even more, because you and the attorney can fall out of love for many, many reasons at some point in the future, and you do not have any of the documents that the attorney sent off on your behalf or that the attorney got from USCIS for you. And then you will have to do another long process to get, to get copies of those. So take an active role in your immigration case. And the same thing goes, take an active role in your case in Jamaica, because you may well need some documentation down the line from Jamaica as it relates to something that happened. It doesn't have to be a criminal court case, whatever, and you don't have any documentation to show, to ground your case. I think another thing that persons probably don't consider enough for immigration cases overall is the fact that when you make an application, it takes time. Some persons will get agitated and they will say, oh, but they say it's 30 days, it's going to take place in 30 days is perhaps an average. What you should do once you've submitted your application is to make sure that you continue to build on the documentation should you be required to do what they call a request for evidence, meaning we're not quite convinced, please send us some additional documentation so that we can ask you to bring these additional documentation for us to further convince us about what's happening. As it relates to your documentation, you can, if your relationship goes south, especially for husbands and wives, if the relationship goes south, the law provides in the United States for something that's called a VAWA, Violence Against Women's Act application. You show that yours was a real relationship by providing the documentation, and there are provisions in the law that allows you to get your green card. However, if you were not taking an active role in your own case, then you will obviously not have a lot of the documentation to be able to use those for such an application, because there are certain documents that the lawyer, if you had a lawyer for the case, cannot give to you under the law. Anything that relates to the petitioner, as person filing for you specifically. So for example, my tax documents, he or she is not supposed to give them over to the beneficiary should the person ask, and so on. But if you already had them because you were taking a very active role in your case, then you can just go ahead and put your petition in for another immigration benefit that you can apply for. But unfortunately, a lot of persons don't take an active role in their cases for a lot of reasons, some of which you can understand. You're afraid, you don't understand, you don't know what is going to happen next. And as such, you perhaps just leave it to the petitioner to do everything. And if the relationship is a marriage, if it doesn't work out, you might be able to apply for another benefit, but you can't because you don't have any documentation to really prove the case. And if, for example, you're doing consular processing, it's important that you have copies of all the documents as well. Consular processing meaning you're going to go to the embassy in Jamaica to get your green card. Unfortunately, if your spouse decides that I can't bother with this relationship, I never know Sister Nadine miserable, and they decide to terminate the application, there's nothing that you can do about that. There's no way to force them to proceed with the application. However, you will have the documents if you're here to put another application in for another benefit. And if you're in Jamaica, if you divorce a person, you remarry, you still have those documents should you be called upon to provide them. I think this probably is a good place, Courtney, to probably talk about some of what's happening now.
Oh, yes, I know persons must be interested seeing all these news.
Now, there's, I don't know, does anybody have any question that they want to unmute and ask? I haven't
in the chat.
If anybody wants to put anything in the chat, fine. So we'll give it maybe a minute or two and see what persons may have. I've got a few questions that I've had before that person sent in that I can probably just
that would be helpful.
A couple of those. I think the main thing persons want to know is the government recently said there's a pause on immigration benefits for 75 countries, and Jamaica for the first time ever on any list was on it. And everybody got really scared. What that mean? I can't apply for my visitor visa? I can't go to Miami for the summer? My mother filing for me? So. No. The information that came out of the government is that immigrant visa processing is paused. That's the word they use. Immigrant visas are those visas for persons who are coming to the United States to live. Meaning, not me who come here on a one entry and decide to not go back. No, you're not an immigrant in that sense. Immigrant visas are for those persons who are going to go to the embassy with their big batch of documents, speak to the visa officer, and the visa officer says, Miss Flowers, I am going to approve your green card. That is an immigrant visa because you're going to get, excuse me, a lawful permanent resident status of the United States. So when you put your foot on that JetBlue or Spirit or American airline or whichever airline you choose to come here with, you are coming as a lawful permanent resident, a green card holder. Those are the persons who are now affected by what is happening. We do not know what this pause means, except that they have said they are going to check to ensure that when persons come to the US, they are not a burden on the infrastructure of the country. However, as an attorney, I can tell you that the persons who have been coming to date must show that they are not going to be a burden, because their petitioners, as a person filing for them, as we call it, their petitioners must submit what is called an affidavit of support. And that affidavit of support says Nadine is petitioning for Courtney, who is her sister. And when Courtney comes, Nadine is earning 10 million US dollars per day. And as such, she will be able to take care of all of Courtney's needs for the next 5 years and will not need the government should Courtney decide not to work and become useful and productive. For 5 years, Nadine is signing a contract with the government to say she will be responsible for her. If she gets sick, I can take her to the doctor. We won't have to use any of the resources of the government. So that's already happening. So we wait with bated breath to to see exactly what the government means that they are going to be doing this deep dive into what the public charge is to prevent persons from coming here and being a burden on the country. Someone just put in the chat that mentioned documents showing lives are merged, more so important than having pictures and videos. What are some of the documents? Well, for every couple, it's going to be different because you may have, especially if you're here in the States already, you may have a lease. If you're not owning a house, you could have a rental agreement to show that you are also on that. You could have documents such as bank statements. It is a fact that there are some banks that are extremely leery, very, very leery of putting the persons who do not have a social security number and therefore most likely fall into the status of not having any status here in the States. Some banks are leery of putting those names on a bank account, but some do. I don't know what their policies are. If you have a life insurance policy with your spouse on it, let's say you came here as a student, you will have a social security number. So that's a little easier. If you have life insurance, car insurance, if you have kids together, then what better proof of the commingling of our lives than the fact that we have little Johnny right here? Looks like his dad, same big nose and same big ears. So we have little Johnny's birth certificate. And of course, affidavits are always useful, meaning you get a letter from Courtney to say, yeah, man, I know Nadine from when, and I know when she and John Brown got married, and oh, it was so wonderful. I was actually at the wedding. I'm the godmother to the baby, and so on and so forth. A few of those from persons who can attest to the life you are now living as opposed to the lives that you lived before. So those are some important examples of documents. I am not saying you can't have a few pictures because clearly what is life without it being in color? So you have a few pictures to show the start, I always say, the start of the relationship, the middle, and the continuation to submit to USCIS. But back to the pause, another question that persons have asked, how is it that we should know what to do about when to send documentation in? They have not said, do not send documents. So my advice to my clients so far, let's continue to put our things together to submit. Because if you wait until whenever this pause ends, you're going to be at the back of the line. To my mind, the most that's going to happen now is when you submit documentation, maybe it will take a little time before it gets to the next stage. And it's taking a little time anyways now. It takes months for documents that I send to USCIS for me to hear back from them that, yes, we have actually received these documents. Persons are also saying, should I go to my interview? Yes. Let them tell you when you go up to Ligani, why are you here? You know, yes, at the pause. No, you go because evidence is important. So when you go and they say, oh, let us stamp. Nadine Jones came here, Nadine Flowers, Nadine Atkinson came here, January 29, 2026, but there's a pause. You have that as evidence. If you stay home on the day that you have an appointment, there will be no way for you to actually be able to verify that you were there. So go, regardless of what you're hearing in the press, I would say go to an appointment should you have one. If you do not have one, then clearly you can't go anywhere. But if you have an appointment, my advice is that you go and let them tell you that, excuse me, you have to wait. For persons who are now putting their documents together, for example, they've now been asked for your police record and your medical. Continue with those. Go down to Duke Street and get your medical. Go up to Andrews Hospital and get your police report, Duke Street. Medical, Andrews. you go and you follow through with all that you can do. Let it not be said that you didn't turn up for your interview, or you didn't upload your police report, or you didn't upload your whatever it is they asked you for, which is usually your affidavit of support, marriage certificate, kids' birth certificate, that kind of thing. And as it relates to your, they call it the SIAC portal, anybody who is doing consular processing and they have got, excuse me, indications from the government that they're to go into that consular electronic application portal, you will have access to that portal to put your documentation there. However, if you do not do anything in that portal for a year, you run a very grave risk of getting your application kicked out. So let us say we do not hear anything more about this pause until February 1, 2027, God's willing, we're all alive and well. And you haven't put anything in that portal because you heard that there was a pause. That's on you, because the government didn't say don't put any documents in that portal. So when you get your police certificate from Rona Duke Street, you put it in there. When you get a pin and then birth certificate from RGD, you put it in there. All of that. Because if you are not in the portal for one whole year, excuse me, it throws out your application, and it's almost the fact that you might have to start again. So continue, I think, with whatever processing you are doing until you have something in writing that you should not go any further. That is critical.
So this is not in the chat, but this question. So we're seeing in the media where it's being said that we have to disclose our social media platforms, and that can impact not only the immigration process, but if you have a visitor's visa, you want to just expound on that?
That's not new. That's been happening for, I'm thinking 5-6 years now that they've been asking persons to disclose their social media. So Hot Girl Nadine, Goody Goody, whatever, all of those you will be asked to disclose. Nothing is inherently wrong with the disclosure. Yes, it might, breach of privacy. If you don't feel like you want to tell them, then they don't have to give you them visa. So you have to weigh that. However, what I always say to people is, remember that online is a footprint, just like you're walking on the road. So you don't necessarily want to put certain things out there. And then it might be misconstrued. For example, Courtney was in a case and she and I were opposing counsel, and I go on my Twitter or whatever, I'm gonna say something to the effect, and then the girl if dead, blah, blah, blah. No, clearly that is just the emotions of the morning because she beat me in the case when I knew for a fact that her client is guilty, because I was a prosecutor for a little time and then defense counsel. Or the other way around, she's a prosecutor and I'm defense counsel. And I win and she go on the online and say, that girl Nadine, she a wicked client, blah, 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 blah. You have to think about what you do. And I mean, there's actually cases like, there's a case like that where the prosecutor, I think it's Belize or whoever, went online and said some very strongly worded things. The point I'm making is think before you type, because it's not going away. Some people will say they're going to delete their social media before they go to the embassy. But remember that, excuse me, all of those bits and pieces of our internet footprint can be found with enough effort, and certainly by persons with expertise, they can find that information. So just be cautious in what you're putting out there, in the same way that you're cautious in your lives. You wouldn't necessarily go to a very dark part of the city at 2 a.m. and show that you have 10 gold chains and 20 million US dollars. So it's the same kind of caution that I urge to persons when they're online, because there's no anonymity online, even though we think we're anonymous. There really is not. So just be cautious. And now are the days where our blood boils for many, many reasons, but let your blood boil in the confines of your bathroom. Just sing it out and be done with it. That's what I advise.
And also be cautious, not only on social media, but how you use your phone, because phones can be seized by the police. And one of the areas that I see them checking the records on the phones a lot is where persons are charged with lotto scamming. So they will take your phone and they will go to the service providers and extract information off your phone. So you have to be very careful. There's a thing called lead sheets on the prosecutions dealing with lotto scamming, and that's where you'll have a whole host of information for persons that you want to approach. So, for example, their name, email address can include banking information, their address, their occupation, things that you will use to assist you in terms of the scamming process. Now, I know no one on this platform is doing that, but it's just something to consider, that your phone can be used against you in many circumstances. So just be mindful of it.
And I'll tell you this too, Courtney, which is probably just in keeping what you said. We don't expect anybody on this platform to be doing no scamming. However, the information you yourself put out can be used to scam you.
Yeah.
Let's not forget that, because all of us are susceptible to clicking on the wrong thing or pressing that link or whatever, or we use our phones for business. So, you use it for your banking and your this and your kids' school and the whole works. And just by sharing on social media, people can know, 1, I'm in Texas. 2, I went to Thailand. 3, I'm going to Abu Dhabi next, and then I'm landing in Jamaica. And just by following your footprint, persons can use very innocent information for nefarious purposes. So you really need to be very, very careful of what you put online, just not regarding immigration or whatever, but just generally speaking. Now, I see we only have about 5 minutes. I don't know if anybody wants to unmute and say anything or drop another question in the chat.
And while the person decide, also be careful of sharing your bank account. Because if persons obtain funds by illegitimate means and then they transfer that money to your account, you can find yourself before the court. That happens quite often. I have a matter right now where there are about 15 defendants, and the money was allegedly shared up amongst all 15 persons. So you have to be very careful. If someone is sending money to your account, you should make a note of the purpose for which that money has been sent. And if money has been sent to your account and you do not know who the sender is, you should notify your bank and try to do so in writing, so that if anything happens later on, you can show the police and say, no, when I got this money right away, I reported it to my bank. So that's just another area as well that I see sometimes people can just overlook it and think that it's not an issue, but it can turn out to be an issue later on in life.
Yeah, absolutely. Well, I don't see any more questions. Just to say thanks to everybody for joining us. We're going to do this monthly. Yes, sure.
Nadine. I have 2 questions. One for you, Nadine, and one for Courtney. In regards to Jamaica and firearm possession law, is it possible that she could elaborate a little bit more on that? And the other one is about the adoptions. I know in Jamaica, we talk about adoption, and is in terms of the number of children, is it a legal adoption, or someone will say, well, listen, I took care of this child for so many years, or this is my sister's son or daughter, and I adopted him, but that's not a legal adoption. It's just a matter that we consider it to be an adoption, but it's not a legal adoption. Is that something? How do you separate that in regards to?
Let me grab that one really quick as it relates to the adoption. That's an excellent question, because that happens every day with immigration. We have in Jamaica this term pumpkin vine relatives. Just as you say, I take care of Courtney from she was 2 months old. Now she's 35, so she's my daughter. But in truth and in fact, yes, I know you're only 21. She is not my daughter in the legal sense, because I did not go through the court process of putting all the documents in court and the court saying, no, Nadine, you are Courtney's adopted mother. So when I fill out the documentation for her to come to the US, and they say, so where is, the documents to show that you legally adopted her? Spirit crying and bawling and weeping and gnashing of teeth because we do not have those. And so she can never come here as my daughter. However, if she's only 12, I can go ahead and put those documentation into the court. It's a pretty long and arduous process, but it is not impossible to do. So you have to be very careful where that is concerned. I'll give the last minute to Courtney as it relates to the firearms, and then we're respectful of people's time, so we're gonna run.
All right, very quickly, yes, I've dealt with firearms matters a lot. In fact, I represented the Firearm Licensing Authority in quite a number of matters. And those matters involve not only applications for firearms, but also where there was a revocation of the firearm user's license. And what has occurred in quite a number of those matters is that when persons are making their application, they might misrepresent certain facts. So for example, as Nadine said, for the immigration processes, for an application for a firearm user's license, if you have a conviction, you need to disclose that. It doesn't matter if it happened 25 years ago. And sometimes people will think, oh, I just got charged for a spliff. Like that's not a conviction. It is a conviction on your record. So again, those are some of the things that you must be mindful of. You have to give correct information. And if it is that you have applied and you want to review any process, there is a review board that is the role of that board is stated clearly under the legislation. If it is that you want to challenge the decision, you can go before the Supreme Court and make a judicial review application. It's a wide area. So I know that you just spoke about it generally. I could do an entire presentation on that, but just to say that that is sometimes what happens where persons are making applications. They may think that they're being truthful about information, but what they have stated is in fact a misstatement of fact. So that's one of the considerations you should have.
So guys, we thank you for joining us. As we say, we'll be back next month. We're planning to do it monthly. So, like, share, subscribe, tell your friends about this general legal session, and we will see you next time. So take care.
Thank you all for tuning in and all the
Thanks
best
again.
for the rest of the day.
Bye-bye.